Good afternoon. My name is Luys Foundation, and I'm the president of the American University of Armenia. It's my pleasure to welcome all of you here today. Every year at this time, on the occasion of Armenian Genocide Commemoration Day, AUA holds a lecture on the topic of the Armenian Genocide or on genocides in general. This year's lecture also happens to be the third in our recently inaugurated lecture series called Thinking About Thinking. These lectures are a collaboration between AUA and Luys Foundation, and we're delighted today to welcome so many people from both organizations, from both AUA and Luys, and the general public here today in the Manugyan Auditorium. The theme of today's presentation is a legal lens on genocide. Before I introduce today's keynote speaker, I'd like to say a few words about the topic of the Armenian Genocide in the context of our Thinking About Thinking lecture series. The purpose of these lectures, after all, is to shed new light and propose new ways of thinking about various topics. One usually thinks of the Armenian Genocide as settled history of events that happened a century ago. So in what sense is it possible to talk about rethinking the Armenian Genocide? How is it appropriate as a Thinking About Thinking talk? I would argue that there are three ways in which discourse about the Armenian Genocide is changing. And these changes are worth examining in some detail. First of all, discussion about the Armenian Genocide is moving away from appeals to morality and toward the realm of law. Concomitant with this change has been movement away from the mere recognition of genocide toward restitution for genocide. For example, we have seen lawsuits in recent years focusing on insurance claims, focusing on the return of property, such as churches, and even on the return of land, as in the case of the lawsuit regarding Incirlik Air Force Base, which is located on confiscated Armenian property. Today's speaker has been instrumental in applying the Freedom of Information Act to the issue of the Armenian Genocide, another legal tactic, which maybe we'll hear about shortly or during the panel discussion. So that's one way. The second way in which the Armenian Genocide might be rethought, if you will, is to examine the tactics of its deniers. This history is very much settled. There's no doubt about that. And since the history is settled and uncontroversial among serious scholars, one might wonder how it is that deniers persist in their arguments against objective reality. And one interesting thing is that they seem to follow strategies that are similar to those of other groups who also argue against objective reality for reasons of political expediency, such as those groups that deny the scientific consensus underlying climate change or evolution. For example, one tactic used by all three of these groups is to advance the idea that the deniers are the ones somehow bravely challenging an academic orthodoxy. This gives rise, for example, to the spectacle of, for example, U.S. Governor Rick Perry likening climate change deniers to Galileo. They're rugged individualists opposing an academic orthodoxy. The interesting thing about this tactic is that the more settled the academic community is on the issue, the better this tactic works. Tactics of this sort need themselves to be studied scientifically, to be the topic of scholarship, lest they undermine the entire methodology of our academic scholarship dating back to the Enlightenment. Once again, today's speaker has been instrumental in examining the tactics used by genocide deniers in the UK's Foreign Office, and he will, in his keynote talk today, discuss genocide denial more generally. Finally, A third way in which discourse about the Armenian genocide is changing is the movement away from regarding it as an isolated historical event and toward understanding it as a historical process. We often speak of the Armenian genocide of 1915 to 1923, but is that characterization really accurate? For an answer to this question, we might appeal to the definition of genocide as advanced by the International Association of Genocide Scholars, the preeminent international academic body devoted to the study of genocides. Now, while genocides may and do happen anywhere in the world and in different cultural and religious climates, the International Association of Genocide Scholars has identified 8 stages that every major genocide of the 20th century seems to share in common. These begin with the identification, the symbolization, and the dehumanization of a target group. It moves on to the 8 stages. The 6th stage is the accumulation of arms. The 7th stage is the actual extermination of the target group. And the 8th stage, interestingly, is denial. Now, because the Turkish government still denies the Armenian genocide, therefore, by this definition, and this is the definition developed and used again by the principal academic body devoted to the study of genocide, by this definition, the Armenian genocide is ongoing. It never ended. It was not 1915 to 1923. In fact, it began in the 19th century and it extends to the present day. Viewed in this light, it has the dubious distinction of being one of the longest ongoing genocidal processes in human history. The Armenian genocide, again, is not an event. It's a process. And it's a process that is fueled, as genocides are, by racial hatred, and it's designed to rid the historical Armenian homeland of Armenians. It began many years before 1915, intensifying with massacres and economic depredations and depopulation strategies of the 19th century. The genocide and deportations of 1915 and the subsequent years led to the Armenian people being restricted to a relatively small, landlocked fraction of their historical territories, much as, for example, American Indians were restricted to reservations in the western United States, or black Africans were restricted to Bantustans in South Africa and Namibia. Even these measures do not seem to have been enough to satisfy the perpetrators of the genocide, however, and it continues to the present day with the blockading of the borders of the present-day Republic of Armenia in an attempt to further strangle it and induce emigration. It is time that the ongoing genocide was scrutinized under the lens of international law. And that gives rise to the title of today's presentations. We are no longer simply asking for genocide recognition in some sense. We're demanding that the genocide stop when we view it as an ongoing process. All 3 of these points of view are ways of rethinking the entire topic of the Armenian genocide. And they are relatively new points of view that I think we'll hear much more about in the coming years as genocide is looked at through a legal lens. For today's keynote speaker, we are delighted to welcome Mr. Geoffrey Robertson, an internationally recognized human rights lawyer and Queen's Counsel, who is the founder and head of Doughty Street Chambers, a leading human rights law practice in London. His specialties include constitutional, international, human rights, civil liberties, and media law. Born in Australia, Mr. Robertson today holds dual Australian and British citizenship. He earned law degrees at Sydney University and Oxford University, where he was a Rhodes Scholar. Mr. Robertson has argued cases before the European Court of Human Rights, the Privy Council, and the House of Lords, and has appeared in cases in countries around the world, including Hong Kong, Malawi, Fiji, Singapore, New Zealand, and Australia. Beginning in 2002, Mr. Robertson served as president of the United Nations Special Court for War Crimes in Sierra Leone, and in 2008 was appointed by the Secretary General as a distinguished jurist on the United Nations Internal Justice Council. Mr. Robertson has led human rights missions to countries such as South Africa and Vietnam on behalf of Amnesty International, and he is also a visiting professor in human rights at Queen Mary College, University of London. 20 years ago, Mr. Robertson successfully defended author Salman Rushdie when British Muslims brought a suit alleging blasphemous libel following the publication of Mr. Rushdie's book, The Satanic Verses. Robertson also hid Mr. Rushdie in his home for a short while after Iran's Ayatollah Khomeini called for Mr. Rushdie's assassination. Today, Mr. Robertson represents Julian Assange, the editor-in-chief of WikiLeaks, in his defense against extradition from the United Kingdom. Among his books are The Case of the Pope, Vatican Accountability for Human Rights Abuses, The Media Law, The Justice Game, The Tyrannicide Brief, and Freedom, the Individual and the Law. Mr. Robertson's book, Crimes Against Humanity, The Struggle for Global Justice, analyzes the development and application of international human rights law, and it's been published in 6 foreign languages. The book includes passages on the Armenian genocide and opens with Adolf Hitler's observation that no one remembers the annihilation of the Armenians. In 2008, the Armenian Center in London retained Mr. Robertson to determine whether the Turkish deportations and massacres of Armenians beginning in 1915 constituted genocide under the standards of international law. The United Kingdom, like the United States, still refuses to officially recognize the Armenian genocide. Mr. Robertson published his findings in a 40-page report entitled, Was There an Armenian Genocide? And you can find this document online if you just Google that title. Mr. Robertson will speak to us tonight about his findings, and his talk will be entitled Why Armenian Genocide Deniers Are Wrong. After Mr. Robertson's talk, Dr. Tom Sanyualian, the Dean of our law school, will moderate a panel discussion on the topic that will include Mr. Robertson, Genocide Museum Director Dr. Hag Demoyan, and Deputy Minister of Justice of the Republic of Armenia, Dr. Geoffrey Robertson. It's now my pleasure to introduce to you Mr. Geoffrey Robertson.
Thank you, Mr. President, for that overkind introduction. It is a great pleasure and a privilege. I thank the university for bringing me for the first time to this lovely and vibrant city to speak of those events 97 years ago that still trouble the conscience of the world. Unlike so many of you here, who feel them in their blood and in their bones and their family memory, that great unrepented wrong, I can claim no connection with them other than very indirectly through my great uncle, William Robertson, who, aged 20, just married, on this night, 97 years ago, was one of many thousands of Australians on a troop ship nudging its way through the minefields of the Dardanelles to reach the Gallipoli beach, where very soon he was cut down by Turkish bullets. He had no idea that that landing would be used as an excuse, as a trigger for the roundup of the Armenian teachers and lawyers, poets and intellectuals in Constantinople to begin a murderous operation so much more heinous than the crimes committed in ordinary warfare. We Australians hold this time as sacred. We call it Anzac Day because it was the first battle in which thousands of our young men lost their lives. But we have no sense of being wronged other than perhaps by the British generals, the donkeys, who led our young lions into a massacre. We were beaten fair and square by the better generalship of Mustafa Kemal. So we hold no grudges, we have nothing to forgive. But the genocide which followed is different because genocide is different. It cannot and should not be forgiven unless and until the nation that is responsible for it acknowledges that responsibility for the worst of all crimes and makes amends. As Germany certainly has by now made amends for the Holocaust. There, of course, we've had the advantage of a trial, the great judgment at Nuremberg, which has confounded the deniers of the Nazi genocide ever since. We have had no judgment on the Armenian genocide, and perhaps it is time that we did judge it, because the nation responsible for it cannot bring itself to own up, cannot recognize that what it did to the Armenian community in 1915 was not just mass murder, not just a crime against humanity, but was motivated by a desire to extinguish a race. Now, it is one thing to establish historical facts and then to analyze, as I shall in this lecture, whether those facts lead us to an ineluctable conclusion as to their correct legal characterization. It is another thing to falsify historical facts, and that, I am sorry to say, is the latest ploy of the Turkish government in its claim last month to have had a Nuremberg trial, not in Nuremberg, but in Malta in 1919, and to have been acquitted. Listen to this statement by the Turkish Minister for EU Affairs, Mr. Egemen Bagis. I quote, "The then Turkish ministers, commanders, and high-level officials were amongst those who were exiled to Malta. They were tried under British control for 2 years. Some 120 people were acquitted of all charges. The ruling was made by a British judge. In other words, Turkey was acquitted in Malta of the 1915 incidents." Unquote. Now, this is a lie, a pack of lies that must be unpacked. The truth is that the Allies established a commission in Versailles that recommended prosecution of the Turkish leaders for what it described as primitive barbarianism implemented by a terrorist system. Britain was the country that took this up after the Treaty of Severance had demanded that the Turkish government supply the evidence, and Britain brought 67 suspected perpetrators to Malta to face trial. They weren't exiled from Malta, they were brought to face trial. But the problem was that as international law then stood, foreign officials of a foreign government, could not be prosecuted for killing their own people. There was, until Nuremberg in 1946, no such thing as international criminal law. There was no crime of genocide or crime against humanity. Now, this was explained to the British Parliament by Lord Balfour at the time. He said, and I quote, "The perpetrators of the Armenian massacres, strictly speaking, had committed no definite legal offences. It was necessary to consider how they could be got at. Talat had said that the Armenians were a constant trouble. He made up his mind to get rid of them, and in consequence he had massacred them en masse. But that was merely the policy of a sovereign government, and the offenders could not be tried by court-martial as they had committed no definite legal offence." That was the position in Malta in 1919. None of these people were tried, as Mr. Baggett dishonestly suggests. They certainly were not acquitted. It was obvious, it was known that they had massacred en masse as a policy the Armenians in Turkey, but because of what lawyers call sovereignty, because of the Westphalian idea of sovereignty, that every country is sovereign, that no other countries at that time could invade other sovereignty by putting their officials on trial, there could be no prosecution. So the truth is that as international law then stood in 1919, a government and its officials could not be prosecuted for ordering the deaths and deportations that killed at least 1 million Armenians, if that was the policy of the sovereign government, and even though it was taken for racist reasons. As Lord Balfour makes clear, there's no difficulty at all in proving their guilt, but there was no international law, as international law then stood, that they had broken. They were not acquitted, they just couldn't be tried, and in fact they were exchanged for British prisoners who were being held hostages in Constantinople. So it really is a shocking lie for Mr. Baggis to claim that Turkey was acquitted in 1919 in Malta by a British judge of any guilt for what happened in 1915. And the very fact that Turkish government officials persist in such perversions of the truth makes it appropriate, perhaps, for a British judge, as I've been for many years, to examine the facts and to decide whether they amount to a legal definition of genocide. The very idea that the Armenian massacres didn't amount to genocide would have amazed Raphael Lemkin, the architect of the Genocide Convention. Mr. Lemkin devised the word genocide. It's a hybrid of the Greek geno, which means race or tribe, and the Latin side, from kaidera, to kill. And he was a man preoccupied by the Armenian massacres ever since the case of Soghomon Tillerian, the Armenian whose family had been killed in the massacres and who in reprisal assassinated Talat Pasha, the man who was particularly responsible for them. And he, of course, had been acquitted after the jury heard the degree of provocation that he had been subjected to. Lemkin was worried about his acquittal because he thought that he'd acted as, he said, as a self-appointed legal office for the conscience of mankind. And he realized that the law, he studied the Malta proceedings, and he realized that the law needed a new crime to cover the mass murdering of their own people by military and political officials. And in his crusade for the crime of genocide from 1933 onwards, it was always the Armenians that he used as the example of why we need a law. I mean, there were historical examples. You can go back to Carthage as the first case of genocide, the Huguenots, the St. Bartholomew's Day massacre, the Protestants in Bohemia, and so on. But, of course, then overtaking that, and he was saying he was advocating a law of genocide as the Nazis were putting the Jews in the concentration camps. And, of course, it was in 1939 that Hitler had said, in urging his generals on the Polish frontier to show no mercy, who, after all, speaks today of the annihilation of the Armenians. So it was particularly the massacre of the Armenians in 1915 that inspired Raphael Lemkin and subsequently Dr. Emmett, the Australian foreign minister, who took up Lemkin's cause in 1947-48, which led to the passing of the Genocide Convention. And in the beginning of the Genocide Convention, there is a veiled reference to the Armenian genocide, and Article 2 of the Convention, which defines genocide, has as one of the ways in which genocide is committed a phrasing that was directly based on the history of the Armenian massacres. Genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnic, racial, or religious group. And then the acts were killing members of the group, causing serious mental harm to members of the group, and C, the section that particularly in the Genocide Convention refers to the Armenian genocide, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. And that, of course, is precisely what happened with the deportations ordered to the Syrian desert, and forcibly transferring children of the group to another group. That, of course, also happened. And so that was drafted with the fate of the Armenians in mind. The Ottoman government had ordered their deportation under conditions that were known to expose them to disease, starvation, and lethal attack by the special organization. The leading textbook, legal textbook on the law of genocide, points out that the treatment of the Armenians by Turkish rulers provides the paradigm for the provision dealing with conditions of life. They were described as deportation. They went far beyond expulsion, because the deportation itself involved deprivation of fundamental human needs, with the result that large numbers died of disease, malnutrition, and exhaustion. So there is no doubt among lawyers today that the Genocide Convention was written on the backs, through the blood of those million or so Armenians who died. Why is the convention important? It is still the legal, the definition that requires governments to act. It is important because America has ratified it. America doesn't ratify all that many human rights conventions. And it was back in ratification came about in extraordinary circumstances. Back in 1986, Ronald Reagan announced that he would visit the the cemetery at Bitburg as part of his German tour. And of course there were SS graves at Bitburg. And there was a young, bearded, obese protester in Flint, Michigan, who heard of this, and he and a friend jumped on a plane with a banner, and they, as Reagan went through the cemetery with the SS graves, they unfurled their banner. And it got worldwide publicity. The Jewish lobby in America went wild, furious that the president should seem to honor SS members. And in 3 weeks later, to pacify them, Ronald Reagan ratified the Genocide Convention. And the young, fat, obese protester from Flint, Michigan was none other than Michael Moore, who was making his first and actually most effective protest. So America has ratified it. It places a duty upon states to intervene, to stop another Holocaust, to stop another massacre. And it is thanks to Lemkin's reading of what went wrong in Malta that we owe Genocide Convention of 1948. But there's more to it than this, because I'm going to come to the errors that are made by the historians, the genocide-denying historians. But what no one has quite taken on is that international courts, sitting mainly in The Hague, although also in Cambodia and my court in Sierra Leone, have been developing international criminal law in the last 10 years. We have looked at genocide. We've looked at it in Srebrenica, we've looked at it in other places in the Balkans, we've looked at it, of course, in Rwanda, that terrible, terrible genocide which took 900,000 lives in 3 months when the Hutus decided to exterminate the Tutsis. We have been redefining and developing the law of genocide in ways that bear directly on the issue of whether you could characterize the 1915 events as genocide. One thing that the cases over Srebrenica have decided is that destroying all members of a group within an administrative region or even a town satisfies the in part requirement of the convention. And the Turkish government, of course, destroyed Armenian groups throughout Turkey. Srebrenica was enough to charge genocide. We've also developed the idea in the Genocide Convention of what it means to deliberately inflict on the group conditions of life calculated to bring about its physical destruction. And that, in various cases in Rwanda, the court has ruled that this includes subjecting a group of people to, I quote, systematic expulsion from homes. Well, the deportation orders of 1915 fall within this category. Other Rwanda cases says that it includes the deliberate deprivation of resources indispensable for survival, such as food or medical services. And this, of course, was a feature of the 1915 deportations that is accepted, it has to be, by all the pro-Turkish historians. The ICTY has ruled that the definition covers the creation of circumstances that lead to a slow death, such as lack of proper housing, clothing, hygiene, or excessive work or physical exhaustion, which were another feature of the 1915 death marches that are accepted because they have to be by the genocide-denying historians. Now, the other issue that we've dealt with in The Hague, in international courts, is the question of what amounts to genocidal intent. And we shall see that throughout the work of the genocide-denying historians, there is this idea, and the genocide-equivocating governments, because I'm going to say there are two. There's the genocide deniers, and then the genocide equivocators, the governments like Britain and America who don't want to offend the Turks. They have this concept of genocide being proved, genocidal intent being proved by an order that is written down. Where is the order for destroying the Armenians, they say? There is no order written down by Hitler for destroying the Jews. There was no order written down by the Hutus for destroying the Tutsis. This is ludicrous. This is a ridiculous idea which is at the heart of a lot of the arguments of the genocide deniers. The courts in The Hague over the last few years have constantly ruled that the intention necessary for genocide can be inferred from other factors. They've listed the factors that words, deeds, a pattern of action, deliberately targeting victims on account of their membership of a particular group, discrimination. You can't get, of course, the heinous intention of genocide from any document. It's never spelled out. You have to use circumstantial evidence. The history of persecution, for one thing, nationalist fervor that the persecutors are full of. And there could be nothing more clear than the Turkification program of the Committee for Union and Progress as evidence of genocide intent. Other familiar indicia of genocidal intent are attacks which single out the intelligentsia or cultural leadership that happened on the 24th of April in Constantinople, and the attacks on group religious and cultural symbols, which happened, of course, throughout. So the court, the ICTY, the International Court of Former Yugoslavia, actually held that, quote, the existence of a plan or policy is not a legal ingredient of the crime. It is the fact in 1915 that the Ottoman government willingly acquiesced and even continued the deportations in the knowledge that many, if not most, of the deportees would die, that fixes them with genocidal intent. And of course there's ample evidence that the CUP, the Committee of Union and Progress, knew of the massacres and were happy about them. Henry Morgenthau complained several times to Talat Pasha about what he called the government's extermination policy. He quotes Talat as saying, quote, "We have already disposed of 3/4 of the Armenians. There are none left in Hitler's Van and Erzurum. The hatred between the Turks and the Armenians is now so intense that we have got to finish them. If we don't, they'll plan their revenge." So in a modern war crimes court, the evidence of Morgenthau would be primary direct evidence of genocidal intent. But the whole circumstances, the fact that the government knew that people were dying on these death marches in their thousands, would fix them with guilt, with command responsibility. So we turn to the evidence that I was asked in 2009 to act as a judge, to look at the available evidence. I didn't see as much of it as I've seen today in the marvelous museum here, which makes such an overwhelming case. But even looking at evidence that was available in 2009, I came to the conclusion that beyond any shadow of doubt, the events of 1915 would be characterized as genocide today, if they happen today in similar circumstances. There was the whole history, the attacks in 1894-6, the 1,000 who were burnt alive in Urfa Cathedral. It was quite plain the government was aware of the historical tinderbox that Turkey represented. The Young Turk movement developed its race supremacy theories. These theories are particularly associated with the build-up to genocide. They involved exclusion of non-Muslims, exclusion of Christians from public office, publicly subhumanizing minority groups like Armenians, calling them tubercular microbes, the national fervor that demanded a warrior nation to prevent the decay of the Turkish race, the Turkification program for excluding Armenian language and culture, the special organization that was formed in Talat's interior ministry, and particularly important, I'll come back to this because it's particularly important today for reparations purposes, was that part of the Turkification program were the government decrees that deprived Armenians of their property. These laws decreed that the Armenian property would be deemed to be abandoned. They directed banks to transfer Armenian assets to what were called liquidation commissions that were established by the state. It is the property, it's odd, isn't it, but it is the law that property lives longer than life, and we sometimes value or at least trace property more clearly than we do human bodies. And that property that was confiscated in 1915 can be the subject of reparations actions for restitution, as I shall explain. And then, of course, there were those telegram directives from Enver Pasha ordering that villages, rivers and towns that had been taken over by Muslims should be renamed if they bore Christian or Armenian names. So the evidence there, the hard evidence, the undeniable, the laws that excluded, that confiscated and expropriated Armenian property, they're still available today for action restitution. But there is a lot of human evidence, evidence by diplomats, evidence from missionaries. And I looked at all of that. I was upset, some Armenian groups, by refusing to consider the Blue Book. The Blue Book has really extraordinary, incredibly moving evidence. And for me, of course, the Blue Book is the Black Book as far as the Turkish government is concerned. Their parliament keeps passing requests to the British government to disown it. But it was, I believe that it's the truth. It was collected by a great historian, Arnold Toynbee, and I think it tells the true story. But I put it to one side, first because the foreword to it was written by Professor Price, who had managed the British government propaganda campaign against the Germans in Belgium, and that rather tarnished it. And secondly, because I didn't think it was necessary, because looking at all the other evidence, the Blue Book can be put aside, because the evidence is overwhelming. And the evidence is not just there's been a great attack by the genocide deniers of Morgenthau. What they don't realize is that the evidence of Morgenthau was supported by Jesse Jackson, the diplomat who was the consul in Aleppo, by William Davis, who was the U.S. Vice, Leslie Davis, very experienced lawyer, who was the U.S. consul in Constantinople, vice consul in Constantinople. Their dispatches utterly support Morgenthau. But there's more than this, because as a judge, the evidence that you particularly rely upon is evidence from, as it were, the other side. You are particularly influenced by people who speak against their own interest. And so it was the German diplomats, Germany in alliance, Turkey chose its alliance with Germany, but what was so persuasive to me were to investigate the dispatches of the German envoys who were Turkey's ally. The German ambassador to Turkey actually cabled Berlin to say, I could quote, "The Turkish government intends the extirpation of the last remnants of the Armenians. Turkification means license to expel, to kill, and to destroy." And it was the German vice consul who reported the Turkish government officials admitting that their purpose was, I quote, the total obliteration of the Armenians. And of course this evidence from Turkey's own allies is backed up by evidence from Christian missionaries, from Lutherans, from German missionaries, and so on and so forth. I won't go on any further on the subject of testing the evidence, but the evidence was overwhelming. It proved to me beyond the shadow of any doubt, put aside the Blue Book, but the other evidence is so overwhelming that this was genocide as defined by the Convention, as interpreted by the ICTY and ICTR. So let's come and talk about the deniers and the equivocators. I read the work of the deniers and of the equivocating governments of Britain and a few others. And the equivocators make one enormous mistake. They say, this is a matter for historians. It's not. Historians, as I will show you in a moment, are utterly ignorant of what genocide is in law. It's not a matter for historians. Genocide is a matter for judges. But we hear time and again, oh, this is a matter for historians. The second great mistake they make is one that I mentioned already, that there has to be some policy order. There has to be a directive from government to exterminate the race. And they keep saying, oh, we can't find a document with Talat's signature on it saying that all Armenians should be deported and destroyed. Well, of course, as I've said, there's no document from Hitler either. But this is a lecture, this is part of a course on thinking about thinking. So let's think about the way these denial historians think. And there are three that I've taken. The first, the most prolific, is Mr. Justin McCarthy, a professor at Louisville University. Not a name to conjure with, but let us move on. He admits, and it's very interesting that these genocide-denying historians all make admissions, that he admits that the Ottoman government, I quote, ordered the deportation to Syria. On the forced marches, great numbers of Armenians died from hunger and attacks. There is no question but that the convoys were not protected by the Ottomans. However, more than 200,000 Armenian deportees arrived safely in Syria. Really, you've got to laugh or it's so black. 200,000 got there, 1 million were killed on the way. This is the way this historian, who I suggest is a propagandist, really writes. But he can't avoid admitting the facts. It's entirely consistent with a finding of genocide. He also goes on to suggest that Turkey suffered more losses than the Armenians. There were more Turks killed than the Armenians. This is a bizarre suggestion, and insofar as I can understand it, he seems to be saying more Turks died in the 1914 to 1918 war than Armenians were killed on the march. I think that's like saying we acquit Germany of genocide and the Holocaust because more than 6 million Germans died in the course of the war. But this is the way he argues. Now, he admits that 500,000 Armenians perished, but he says as a result of their armed rebellion against the Ottoman state. Wait a minute. Those who were killed on the marches were largely women, children, and old men. Were they in armed revolt against the Ottoman state? This is the way of a propagandist rather than a historian. Now listen to McCarthy. He says the causes of death were sickness, exhaustion following long marches, immediate change of climate, and the attacks of marauders upon rich convoys. Now I make 2 points. The ICTY jurisprudence makes it absolutely crystal clear that any government that orders deportations, knowing that those people on them will die from sickness, exhaustion, following long marches, etc., will be guilty of genocide. Conditions of life that can't be sustainable. So McCarthy just doesn't understand the law of genocide. And then but notice the language, the rich convoys. Seeing those pictures in the Genocide Museum of the poor, struggling people with their few possessions, some of them, I think one of the photographs here, with no possessions at all. What are you trying to say? That these people died because they were rich, that they had all their rich objects on their back. It's very distasteful, disgusting, I think, and it does show the extent to which Professor McCarthy has become a propagandist and a very unattractive one. Yes, he goes on to say, oh, more Turks lost their life in the war. I mean, this is just irrelevant. So, as far as McCarthy is concerned, I think we can see him as a rather perverse propagandist for the Turkish government. Bernard Lewis, the second genocide denier, is a different matter. He's a well-known professor of Middle Eastern Studies. And he was actually prosecuted in France. I'll come to comment on the French law in a minute. He was fined for denying the Armenian genocide, but he was only fined a franc. And he said that what he was doing was trying to distinguish between the Armenian massacres and the massacres of the Jews in the concentration camp. And he said, the Turks certainly resorted to very ferocious methods, but he said, quote, there is clear evidence of a decision by the Turkish government to deport the Armenian population. There is no evidence of a decision to massacre. So Luys, you see, falls into this trap of historians who are ignorant of the law of genocide, because there doesn't have to be written evidence of a decision to massacre. There never is. The fact that he admits there is clear evidence of the Turkish government's decision to deport the whole Armenian population in circumstances where, of course, most of them died, shows that, properly analysed, Bernard Luys is simply ignorant of the law, one of these ignorant historians who doesn't understand how legal thinking operates to establish a legal characterization based on fact. The third genocide denier, who is used by the genocide equivocators to show that historians differ, is Dr. Heath Lowry. He's a rather controversial figure. He has the Ataturk chair at Princeton University, and he was caught out drafting letters for the Turkish ambassador to deny the genocide. And he was condemned by a wide range of intellectuals, Arthur Miller, Susan Sontag, William Styron, Kurt Vonnegut, Seamus Heaney, and so on. But he, too, seems to be one of these confused historians who doesn't understand the law of genocide. And he says, well, it was a human tragedy, but there's no evidence that it was pre-planned. I'm still looking for the document. Mr. Heath Lowry has unique access to the Turkish archives, which is not vouchsafed to historians who are not Ataturk professors in chairs paid for by the Turkish government. But it's nonetheless, when you examine what he says, none of it is inconsistent with, but much of it is supportive of the legal characterization of genocide. So that's the way they think. They think without knowledge of the law. They're not lawyers. They are historians who have a perverse view of the law of genocide, and their genocide denial is based on that view. What about the equivocators? How do they think? I'll tell you exactly how they think. The Armenian genocide is accepted by 23 governments. It's accepted by all serious genocide scholars and their associations, but the truth has become hostage to realpolitik, and by US and UK governments who find Turkey at the moment in particular too important to affect. They dare not use the G word. So what do they say instead? The UK for many years answered questions about the genocide by saying that the evidence was not sufficiently unequivocal. What a marvelous phrase, not sufficiently unequivocal to call it genocide. Now, the truth behind that was I discovered by getting some secret documents under the Freedom of Information Act, which told me the real reason. Internal documents said the government, this is the British government, is being unethical in this answer. It's open to criticism in terms of the ethical dimension, but given the importance of our relations, political, strategic, and commercial, with Turkey, the current line is the only feasible option. So there it is. in black and white. We're lying, we're being unethical, but by God, we need Turkey so much at the moment that we've got to do it. And Turkey is neuralgic, is the word that the British Foreign Office uses. Crazed, insane when it comes to allegations of genocide. It's rather amusing in a that sort of way to remember what the British government actually said at the time. Here is Lloyd George, the Prime Minister of Britain in 1915. These atrocities are almost unparalleled in the black record of Turkish rule. If we succeed in defeating this inhuman empire, one essential condition of the peace we should impose was the redemption of the Armenian valleys forever from the bloody misrule with which they've been stained by the infamies of the Turks. Well, not sufficiently unequivocal. Lloyd George. Winston Churchill, who was himself no mean historian, said in 1915 the Turkish government began and ruthlessly carried out the infamous general massacre and deportation of Armenians in Asia Minor. There is no reasonable doubt that this crime was planned and executed for political reasons. Whole districts were blotted out in one administrative holocaust. There is Churchill at the time using the word holocaust. Prescient political figure. So that is the reason why they are equivocating. They're afraid of upsetting Turkey. Now, since my report was published, I'm glad to say that the British government has not only read it, but changed its tune. It no longer says that the evidence is not sufficiently equivocal. In relation to my report, it says the British government recognises the terrible suffering was inflicted on Armenians in the early 20th century. We must ensure that victims of that suffering are not forgotten. But the main concern of this government is not what we call such horrific events, but how we can ensure that lessons are learned. Well, we ensure lessons are learned by calling them what they are, by calling them genocide. And then it goes on, we endeavour to restrict our use of the term genocide to events which occurred after the adoption of the UN Convention in 1948. However, we acknowledge the strength of feeling about this terrible episode of history. So there it is. They've abandoned the claim that it's a matter of a historian. The evidence is not sufficiently unequivocal. Their current weasel words are that we don't want to use the G word for events before 1948. So we don't want to call genocide the concentration camp massacre of the Jews. Come on. Yeah, this is the British government, the British Foreign Office, at its weasel worst. But there it is. As for America, the Foreign Affairs Committee voted to acknowledge the genocide. First the Bush administration, then the Obama administration ducked it. President Obama, when he was running for president, said he would recognize it. Now that he's president, he doesn't use the word. He does, however, say in one of his messages, the Meds Yekon, my mispronunciation, but I am an Australian, I don't know, it must live in the memory. And that's, I guess, equivalent to referring to the show as the Holocaust in the Jewish code. So it can kind of refer to it in code, but Turkey is important, and so that at the moment is the realpolitik. But France and Switzerland have made it a crime to deny the Armenian genocide. I don't think this is a good idea. It allows the genocide deniers to claim that their right to freedom of speech has been denied. It gives them more publicity, and it permits political stunts like that of the infamous Mr. Baggis, who went to Switzerland recently and said, I quote, I deny that the incidents of 1915 amounted to genocide, so prosecute me. This was a totally dishonest stunt because he knew that he had diplomatic immunity and he couldn't be prosecuted. So his defiance was completely bogus. But it does. These laws, criminal laws, genocide denial, seem to me to be wrong in principle. There was a provisional agreement of Turkey's offer of a protocol and a commission of historians. I think the Armenian government was right to reject this because, as I've explained, historians are not judges, they don't understand the law of genocide. I'm certain that any honest court, reading and applying the decisions on the genocide conventions given recently by the international courts in The Hague, would have no doubt at all characterizing the events of 1915 as genocide. So, I believe that the next step should be to get this issue before a court. There are actually still Armenians alive today who were children, small children, on the death marches, and whose memories have been tormented ever since. There have been legal actions that were seized in 1915 by those notorious liquidation committees. Are there courts available to hear those cases? Yes, in America, the Alien Tort Claims Act of 1799 allows actions for historic wrongs if you can find an emanation of the Turkish government that isn't covered by state immunity. There are some. And closer to home, there is the European Court of Human Rights in Strasbourg, which has recently found, in a case ironically against Armenia, that it can deal with claims, property claims, against states for seizure of property in the distant past. So restitution is an even more appropriate way to raise the matter in the European Court, and there is an even more appropriate way. There's a little-known provision in the European Convention which provides for states to bring actions against other states. It's been used against Greece quite often in the time of the Colonels. It was used by Ireland, the Republic of Ireland, to raise an issue against Britain over internment. And so it may be time for the Armenian government to institute an action in the European Court of Human Rights, calling perhaps on the court to declare that the notorious Section 301 of the Turkish Penal Code, which punishes anyone in Turkey who asserts that the 1915 events do amount to genocide, is incompatible with the European Convention. So there is a live legal issue here. There are courts where it can be possibly raised. There can be no institution better, in fact, than a human rights court to decide it. The issue of the Armenian genocide can no longer be left to history. It certainly can't be left to historians. It is a matter for judgment, applying the developed law of genocide to the evidence. And in my judgment, there can only be one answer. Thank you.
Robertson, for a very insightful and stimulating explanation of the situation that we currently face as Armenians and as lawyers who look at the issue of genocide. I would now like to invite our other panelists, Dr. Giragosyan and Dr. Demoyan, to the dais, and we'll begin. I'll ask them to speak first and then turn the floor over to Mr. Robertson again to wrap up, after which we'll take some questions. Okay, we'll begin with Mr. Demoyan.
Good evening, everyone. First of all, I would like to say thank you to the administration and the leadership of American University of Armenia for this great occasion to communicate with Mr. Robertson. Actually, we held a joint press conference at the Armenian Genocide Museum. I'm sure many of you read the initial report put on our website in English and in Armenian translation. Well, you can find a lot of things there on how the Armenian genocide and as a historical fact was manipulated by the government. This is one of the issues. Well, I would like to apologize a little bit because I'm exhausted, and you know well why I am exhausted during this day and the next day. But I'm sure that there will be a very interesting discussion today. Mr. Robertson quoted two British leaders, actually, on what they said about Armenian mass killings during the First World War. I would like to bring your attention a new revealed fact, which deals also modern attempts to deny using various verbal manipulations. Mr. Robertson, I would like to quote the very same Lord George, British Prime Minister, who during the peace conference in 1990 surprised and shocked with the rhetoric of Turkish side on how Turks also suffer. What he said is, I'm trying to bring the exact words of the Lord George. He said, look, he was talking with the colleagues, allies, during the peace conference. He said, look what Turks say. They say, we also suffered during the Gallipoli operation. We lost a lot of forces there, or maybe much more than Armenians were killed in Anatolia. And Lord George was surprised. And look what Davutoglu and Erdogan, they say. They exactly repeat the same rhetoric. Nothing is changed in denialist approaches. When denial started, actually, denial started from the very beginning when the decision was passed. Every genocide has its own logic of the denial too. And not only logic, but also the policy. Turkish government was ready beforehand, before the first orders went to the districts, to the local gaimagams and other governors. They prepared very well their prepared excuses on how to explain what they are doing. And it was not the passive actions. They had active also publishing activities. The first denialist books actually appeared in 1915, 1916 in many languages. And if you check those denialist books, actually they are monumental denialist books, because the very same pictures I watched by Turkish TV when I was 10, 11, 12 years old. I was born in Gyumri, and the satellites were too strong, so we could catch 4 Turkish channels. Exactly the same pictures. People called terrorists, and a lot of armament laid on the table. They were catched every day. I watched the same scenes, which now I can check in 1916 books printed in French, in German, in English and Ottoman Turkish. The same line of Armenian prisoners, a lot of fresh German armament, newly confiscated. But several pictures are very interesting there. Pictures of so-called Muslim victims and mourning ladies around them, Muslim ladies. What is written there? At least you can find 4 pictures taken from different angles. But if you look attentively at the dresses and the females surrounding the bodies of so-called Muslim victims, you will find out that the victims are the same persons, bodies are the same persons, and the females are the same persons. But what is written on the bottom of this first denialist book? Different regions. Muslims killed in Diyarbakir, Muslims killed in Van, Muslims killed in Harput, but the same photo, taken from different angles. So, welcome to denialist form. So now what we have with the Turkish leadership now, we have very sophisticated attempts to deny the historical and legal facts of Armenian genocide, but also there is another intention. They never hide that they get prepared for 2015. Getting prepared with the new skills, new instruments, new approaches, and more sophisticated approaches to deny. Hiring academia, paying academia, establishing new chairs, opening the archives is also an important part of the denialist policy. Opening archives, restoring Armenian monuments is also part of the general plan. What does it mean, restoring the Armenian monuments? We all know. Last year, the Queen's burial, Armenian Queen Katranidis' burial site was desecrated in Ani. All khachkars were broken to pieces. Tombstones were crushed. Well, recently in Paris, I joined to the conference where a couple of French origin, I cannot say their names because I never asked the right to say, because they are doing their job in Turkey. They showed us a list, instruction of the company which produced metal detectors. And what is written in that instruction, which is on free sale in Turkey. In Turkish, it is written that if you want to find treasures, you can find them on the fundaments of Armenian churches or on the territory of former Armenian cemeteries. And it is on free sale in Turkey. And no one gets punished because of that. What is denial? Denial also is the state policy when Ogül Samast was captured by Turkish police and taken into custody, and the policeman posed with the murder on his hands. Blood of Hrantdin was very fresh, but they posed as a hero. And what is the background? If you look at the video footage, you will see Atatürk, Turkish banner. And what Turkish Prime Minister said? They said, we have to catch and punish those who put this video footage on internet, but not those policemen who posed with the murder. I consider this as a continuation of the crime, and is a part of the denialist also, in my opinion. Denialism has many, even ridiculous. Actually, denialism, my great friend Israel Charny called as a part of psychiatrist issue. Every denialist is sick, he claims, because he is psychiatrist. Now, let's imagine and put yourself on the position of not an ordinary Turk. I have nothing against an ordinary Turk, but the Turkish leader who try every day. They think what new bring in denialist war, what kind of new approaches to develop, and always they become ridiculous because one day they change names of towns and villages. Another day they change internationally accepted names of animals and herbs. Yeah, because there is an Armenian mouse or Kurdish snake in a Latin biome, so it is dangerous. It is dangerous, of course. But my word also I want to transform to the modern realities. What is Turkish state approach towards Armenian statehood? The Turkish denialism, modern denialism, yes, it is continuation of genocidal policy, no doubt. But what is the Turkish state approach towards Armenia when country using the ultimate approaches of the military acts, which is blockade? The next step after blockade is declaration of the war. But what kind of rhetoric and slogans are used? Racist and xenophobic. And it's not a matter of only 301. One nation, two states. It is very racist. Racist slogan. When you develop joint policy with Azerbaijan against Armenian statehood. Actually, we can talk more about overall policy of Turkish Ottoman approach towards Armenian state and modern Turkish approach towards Armenian state. Armenian statehood for Turkish leadership always was anathema. The very existence. And a lot of euphemisms were used by Turkish leadership, pointing on Armenia as a separate unit, as a statehood. Second Bulgaria, second Israel, they heavily used during the Karabakh War. And what Turgut Özal said in 1993, when Armenian self-defense forces were successful after counterattacking Turkish Azerbaijani offensive, they said Armenians never learned lessons what happened in Anatolia. What is this? This is approval of what youngsters did, and Kemalists continue it, and Republican leadership till now, they are pleased with the results of the Armenian genocide. And I believe that border closed is not only a matter of Karabakh. This is my personal opinion, maybe I'm wrong, and maybe you can argue. The very fear, Turkish fear of Armenian existence on the territories claimed of Armenians, this is the main reason why border is closed. It's not a matter of Azerbaijan, first of all, and the Karabakh. Any Armenian heavily representation on a territory of our homeland, part of the homeland, this is great anathema of Turkish modern leadership. And denialism will continue. But my word, I want to conclude my word saying that in any case, historians, Mr. Robertson, historians, I'm historian, historians did their job. They finished. They finished their job. No need to check additional materials or reveal something, huge archive folders, trying to prove what happened, or write down new survivor stories. No, no need, because historians proved that. The evidence is clear, it's on table. The next step, next voice will be of legal issue. And we want to hear you. Thank you.
Thank you very much. I'll turn it over now to the Deputy Minister of Justice, the legal specialist.
Thank you, Mr. Samelian. Before I start speaking about the topic, I just want to make a disclaimer that I'm here not in the capacity of a Deputy Minister, but in the capacity of co-founder of International Competitive Law Center. So, in the capacity of international law specialists. So, and I'll speak in that perspective. And this is, first of all, a great honor to be on the same panel with Mr. Robertson, and thank you for that, for inviting me to speak in front of this auditorium. And the issues about the legal aspects of Armenian genocide and responsibility for Armenian genocide have been continue to be in the center of many international lawyers in Armenia, and they continue to be as well in the center of my research interests. And when I was really excited and really glad, happy to read a couple of years ago the famous report by Mr. Robertson, and I was really satisfied to see that research is being continued in that sphere and by such a prominent specialist in that field. So starting with my own view on this topic, I'll just try to touch or to make some comments with regard to state responsibility for the crime of genocide, which is, I think, one of the big and more important issues, and is becoming more important by the time. And especially making a reference to recent judgment by the International Court of Justice in 2007, the Bosnian genocide case, when the court admitted based on the interpretation of the wording of the Genocide Commission, notwithstanding the fact that there is not a specific mentioning about the state responsibility for genocide, still state can be held responsible for genocide or not preventing the genocide. Though in that case the outcome was negative, but the reality is that this authoritative legal body accepted the notion of state responsibility. So now going back to the Armenian genocide, what I have in mind when I was thinking what I will speak, I'll construe a legal scheme, or I construe several steps that a lawyer, an international lawyer, should make in order to prove the existence of responsibility for that crime. First of all, I'll start speaking not about the primary rules, which Mr. Robertson started to speak, basically meaning the rules which are describing the content of the crime, but I will speak a little bit about the secondary rules of international law, which actually regulate the application of those primary rules, meaning the rules which govern the existence or the creation of international law, for example, the customary law process, and the rules which govern the process of responsibility, the procedural rules. So going back to Armenian genocide, what do we have back then? What legal body did we have then when the actions, the atrocities were being committed? We didn't have the Genocide Conventions for sure, convention for sure, and we didn't have any specific treaty or convention which was regulating or codifying the prohibition of that crime. So which means that the other source that we should make reference to is customary law. So what kind of customary rules existed by that time when the actions were being committed? I made some brief excursus to that period of time when the actions of genocide were being committed, specifically starting, for example, with the Peace Treaty of Sevres of 1920 between the Allies and Turkey, which actually did not come into life. Though, if you look at the wording of that treaty, it explicitly includes the admission that the actions, the massacres, atrocities committed against Armenians in Ottoman Empire were being considered by the international community at that time as a heinous crime, so meaning as a violation of international law. More than that, and going beyond that, after that treaty, even some actions were committed, or some steps were taken by Turkey, meaning the several in absentia trials of those who were responsible for the Armenian atrocities, from which we can imply that Turkey admitted that there existed a binding international law which prohibited those kind of action. Which brings us to another source of obligation under international law, which is called estoppel, which I would like you to pay attention to, which I think may be a basis for asserting the existence of legal obligation at that time. So if we do this little exercise with regard to the existence of the applicable rules of international law by that time, then the second part of the exercise which we need to conduct is the exercise of transferring this responsibility assumed by the Ottoman Empire to the modern-day Turkey. How you do that? In contemporary international law, those who study, and I'm sure that many law students in the auditorium know that there is the concept of the state succession. The state succession, the concept of state succession, or more specifically the provisions regulating these relations, they also they do not have the codified, but they include the rules concerning the succession of responsibility. In recent international legal scholarship, there are some scholars who started to speak about this concept, and I think there are a few monographs in the field. So and also aside from the legal scholarship, the notion of succession of responsibility of a state has been continuously discussed in the jurisprudence of the Permanent Court of International Justice, and then afterwards other tribunals and courts. So the idea is that based on this concept, it is feasible to prove the existence of responsibility of modern Turkey for the violations that took place in the beginning of 20th century, and to try to bring it to justice. And this is I'm speaking about the speaking about the violations or the breaches of international obligations. I'm not focusing on the term of genocide currently because I, as a lawyer or as an international lawyer, do not believe to the notion of retrospective applicability of the Genocide Convention. So that's why I'm speaking about violations. So my idea is that no matter how you call it, whether you call it a genocide or whether you call it atrocities or massacres, it doesn't change the content. It means that the genocide, the generic term genocide, was developed a little bit after that, and in the course of development of international law. But it doesn't mean that the actions committed by them then should be left without punishment or without responsibility. So this is these first two steps. Next, the third step, which is important to think of or think about, is the steps forward. What do we need to do based on this reality, based on this legal reality? How can we act further? Mr. Robertson in this speech mentioned several options, starting from bringing some claims before the European Court of Human Rights, based concerning the living legal questions, as was described in the speech. I agree with that notion, which is a really interesting path to go through. Another path that I see as a lawyer may be starting or triggering the mechanism of International Court of Justice. I wouldn't be very optimistic about that, but I would advocate for starting in that with the advisory proceedings before the court. In this case, it is important to phrase the question, the legal question, which will be put before the court very accurately in order to get the right response that we want to get. And the other option that I have been thinking of may be the creation of a common claims tribunal, but which can be assessed to be less probable than the first option between Turkey and Armenia to consider the legal questions. Not the one that was proposed in the protocols, but another one, a tribunal, which will deal with legal issues. So I will not go further to not to bore you, and I'll be open for answering any questions. And thank you for the opportunity to speak.
Thank you very much. I'd like to now turn the floor back over to our guest, Mr. Robertson, to say a few words, and then we'll have an open question and answer.
Very briefly, I agree with our museum director that the historians have done their work, and they should stop. They have done what historians are there for, namely to produce the record. The problem is that some of them keep interpreting the record, and they're not qualified to do so. They're not qualified as international lawyers. So we agree on that. Now, fascinating to hear that the Deputy Minister is thinking in these ways. I think state responsibility, which I didn't touch upon very much in my lecture, is very much alive as a result of the decision that he mentioned, the Bosnia and Serbia
case. It's a very interesting case where I think, as I analyze it, it totally supports the Armenian side. When you look at the historical evidence, you see that there are, what lawyers who always speak in Latin call de jure organs of the Turkish state, sending out the deportation orders, ordering the liquidation commissions, and so forth. You've got the de facto organs of the state, such as a special organization, the secret police, and so on. And you've also got bodies that were acting with the complicity of the state, the marauding gangs of Kurds and so on, who were never punished, never stopped, and were actually encouraged to attack the convoys. So you have all those indicia of state control, and I think the Bosnia and Serbia case does make a claim for state responsibility. We agree that the European Convention of Human Rights would be a way to forward. We would agree, I think, that those title deeds and so forth, although the claim would not necessarily, as you say, be based on genocide, it would nonetheless be reparations for expropriation, for wrongful taking, for torture, for loss of life, and so forth. The right to life under the Article 2 of the European Convention, which is now part of the law of Armenia and Turkey, let us remember, the right to, and so forth. Well, go on, the right not to be discriminated against under Article 14, the right to an effective remedy under Article 30. It's all there. I think what is very interesting, and where the Deputy Minister has really got a great idea, is to try to get this to the International Court of Justice. This is not easy because it is a familiar feature of the work of the International Court of Justice that when you bring a claim against a country which has a chance of success, that country suddenly opts out of the protocols. Because when Australia brought its claim against France for nuclear testing, they pulled out. When Nicaragua brought its claim against America for supporting the Contras, they pulled out. So the only way of being surefire on this is to get the General Assembly, or maybe UNESCO, because UNESCO has to refer an issue to the International Court of Justice. That is how the legality of nuclear weapons issue came up. That was a reference, I think, from the World Health Organization and from the General Assembly. That is how the Israeli wall, the legality of Israel building the wall, got to the International Court of Justice. That was a reference, I think, from the General Assembly. So Armenia might, and Turkey can't stop such a reference. So if, and we have 23 nations already have actually formally recognized the Armenian genocide, build on that, get the support of some of the non-aligned states, and there will well be a reference on the issue of whether the events of 1915 amount to, I framed the question, I think I put it this way, should the same events occur today in any country with a similar history to that of Turkey in 1915, will the Genocide Convention be engaged and require the prosecutions of the perpetrators? But you could formulate it in a number of ways, but to put the issue of whether, and I agree with the Deputy Minister a lot, there are a few, not perhaps top-notch legal scholars who think that the Genocide Convention is retrospective, or that there was a law of genocide before the Genocide Convention. I don't think that's right as a matter of law. One's got to be a positivist up to a point on issues of law, as the Deputy Minister and I would fit in that category, and so we can't twist the law like that. But I think a General Assembly, if the General Assembly or if UNESCO, because this is partly, remember, a cultural issue where a lot of Armenian culture was destroyed, that UNESCO would have the power to make a reference. And with America out of UNESCO, temporarily I hope, because of its is, I think, the next steps.
Thank you very much. I'd like to thank our distinguished panel for taking time to discuss all this. I know it's a very busy time, especially for the director of the Genocide Museum. Nevertheless, if we could try and keep our comments to another 15 minutes or so, questions and answers. Any questions? Please.
I've got a question. What would your...
If you would say which of the panelists you're directing it to?
Yes, Mr. Robertson. I've got a question as far as what your advice would be to the lay public at large, as far as what we can do for effective policy pressuring Turkey and denialists or acquisitionists.
Okay, the suggestion is that we'll take all the questions at once and then we'll answer them as a panel. So are there other questions? Yes, please.
Yes, thank you very much, first of all, for a very interesting presentation. I have actually two questions. One of them may be more directed toward Dr. Demoyan or Dr. Kirakosan, and another for Mr. Robertson. The first is, okay, suppose tomorrow Turkey does a turnaround, comes out and says, you know, we've discovered some new documents, new evidence, whoops, it happened. So what then? I mean, I have been participant in a number of discussions about retributions, reparations, consequences, and I haven't met two people who have the same opinion about it. So I would guess that there need to be some mechanism, I would say instituted at the government level, since the government is the center not only of Armenia, but to a certain extent of Armenian nation, that will be involved in developing at least mechanisms, if not specific measures for retributions. Please, I would like to hear your thoughts about that one. And the second question, Mr. Robertson, you were talking about the denialists, some other tactics that are employed by Turkey and its supporters for denial. But recently I have noticed, and I may be mistaken, I have noticed another trend, especially on part of Turkey and the states who are close to Turkey, like or Azerbaijan, like Pakistan, like others. They are starting throwing around the term genocide quite easily, without any factual evidence and without any like real facts. Do you think it could be a new tactic, or maybe not a new tactic, aimed at devaluing the term genocide in general, so that in the end it just either goes out of circulation or it doesn't carry the same responsibility that it would have otherwise? Thank you.
Other questions? I think we'll take maybe 2 or 3 more, and then that'll probably be enough for our panel to keep going for more than 15 minutes.
Hi, Lily Nesam from Political Science. Lily Nesam from Political Science. Do you think that there was, if in Turkey there was real democracy and freedom of speech, the citizens of Turkey will accept the genocide on Turkey in this place? Thank you.
You, other questions? Yes, we'll take one from here. Oh, and then one from here.
One of the most famous Turkish newspapers, Taraf, almost a month ago represented an article which claimed that in 2015 Turkey will recognize the Armenian genocide. What do you think about this?
Thank you very much. And a question from here?
Yes.
A sense of theme developing here.
I'm actually kind of going to break the theme here a little bit. Dr. Boasian in his opening remarks mentioned that the battle has gone from the moral front to the legal front, or that's the direction that seems to be emerging. And I'm wondering if on the moral front we've exhausted the opportunities. For instance, have we done enough as a state, the Armenian government, as a state and as a nation, to thank those who helped us, who were on our sides throughout the suffering? The Arab families, the Turkish families, the Kurdish families who helped us in many ways to protect us. Have we done enough on that front? Another, for instance, in Colombia there's a city named Armenia. The history of that is that during the Armenian massacres, news got around that Armenians were being massacred, and in honor of those people massacred, killed, the citizens of that city, newly formed city, decided to name their city Armenia. So there's a lot of this historical debt of gratitude that perhaps we could use, and I'm wondering if that will have any bearing on the legal outcomes or the diplomatic outcomes.
Thank you, and I'll editorialize here to say that we also owe great debt of gratitude to those who have the courage of their convictions today and still speak up, like Mr. Robertson. Please.
A question from me, and probably it's also related partly to the issue of gratitude. Back in 2009, President Obama started to speak Armenian. Before that, he was using the word genocide, and after that, he started to use the word Medziyerer. I think that we have to thank President Obama for that, for speaking Armenian. But my question is the following. Yes, if the word, if the term Medziyerer is synonymous in Armenia to the word genocide, does it mean that by using the word Medziyerer, same as probably Holocaust for Jews, President Obama recognizes the genocide? This is first. The second, in that speech, there is a sentence where President Obama says that something serves as an ultimate rebuke to those who tried to destroy Armenian people. This means that he accepts there was an attempt to destroy Armenian people, which is the genocide by definition, and we know that President Obama is a lawyer. Does it mean also that Mr. Obama recognized Armenian genocide, same as if someone would say that someone tried to cause death, this is just an attempted murder? Thank you. And do we need to thank Obama for that?
Spoken like a lawyer, which he is. Okay. Do we have any more questions? I think we'll just take two more, and then I think we have too many questions already.
Hello, my name is Rubina. I'm a granddaughter of a genocide survivor. I have one question, 3 issues concentrated in it. To Dr. Robertson, and what do you think, how realistic is the return of the homeland of the Armenians? And also, what do you think, which country should recognize the genocide that will boost other countries to recognize it quicker? And what do you think, why doesn't the Israeli government recognize the Armenian genocide? Thank you.
Okay, many questions in one. This really will be the last. Okay, so this gentleman, please.
All right. It's peculiar that at the heads of most international courts and behind the decision-making processes are often European, British, and American officials. Most of Europe was involved in the slave trade, as was America. In addition, America, in its post-founding years, was responsible for the explicit annihilation, both physically and culturally, of Native Americans across the country. If countries like America and Great Britain or the International Court of Justice were to acknowledge and even bring to court the case of the Armenian genocide, for lack of a better term, would a Pandora's box of sorts be opened up for these countries? What would be the implications of such an acknowledgement? And therefore, is the idea that America and Great Britain, is the idea that they do not want to upset Turkey merely a convenient diplomatic excuse, as not to stir the settled dirt of their own history?
Thank you. The questions give us a lot to think about, and now we're going to see what the panelists think about all the stuff that you've all been thinking about while you've been listening. Who'd like to begin? Why don't we go in the same order?
Okay. Let me to try to prove that a historian is not feeling uncomfortable sitting next to 3 lawyers. Okay, my answer is short to Taraf. I've never read such an article that Turkey will recognize, or is going to recognize. Why to wait 3 more years? Why to wait? But now switching on the question gentleman asked about how we should be ready in case Turkey one day will say, okay, we found that. It means that whoops is not answered. So if state accept the crime, it means responsibility. Am I right? Good.
Words on consequences.
When they said that something bad was committed in terms of ultimate crime, genocide is ultimate crime, it means that Turkey at the same time accept not the historical fact but also legal responsibilities for the crime committed. So what must be the Armenian side steps? This is the issue. This is a really challenge. We should work on the big five, on the how and what we are going to claim. At this moment, we have desperate, sporadic, and distorted approaches of this. State and diaspora, they have to unite their efforts in order to develop a common agenda, what we want and how we want to claim. In case of this, they mix. But what we have, let's be realistic, and I want to touch this issue, despite this very painful too. We had a couple of years ago the settlement of these policies, the New York life insurance and the AXA. Some people got money from the bank accounts and this as a process. But people who were involved in that settlements, or other words, I don't know what is good in this case, they started to sue each other. This is also another big problem, and I don't want to escape while speaking about this. What does it mean? It means that the matter in such cases must not be as a matter of individuals, lawyers or attorneys. It must be united, all Armenian matter, and this must be developed first. We cannot speak with different languages. We cannot claim different things. We have to claim a common thing. And what I call, and it's not my copyright on this expression, elimination of the consequences of the genocide. Genocide is a crime. There are still consequences of this crime. And these consequences must be eliminated, starting from the church property, starting from the restitution and the settlement of property and the business rights of the individual families. A lot of Armenian families, they keep still not only the keys of their sisters' homes, but they keep also property documents, maps, property papers. Some of them also is available in our museum. But I know many, hundreds if not thousands cases when these papers still can work in courts, different courts, and we have to be ready in order to develop our state-by-state policy on how we should develop our common agenda, but not the sporadic, local diaspora community-based or only Armenian-based. State and diaspora structures must work together in order to develop one language and one claim. As for UNESCO, let me to say a few words. I want to speak from the realist point of view. UNESCO is the organization which still did not react on Armenian cultural heritage destruction in Nakhichevan. So I'm very pessimistic, Mr. Robertson. Having video footage, a lot of photos showing the exact process of the destruction, but still there are excuses that Azericide is against for UNESCO inspectors to go and see what exactly happened. So this is as a part of modern political realities. Thank you.
Thank you. Would you like to speak next?
Thank you. Answering the question, what if the miracle happens and Turkey turns to us and says, yes, we did it, and we admit it, we admit the fact. As a lawyer, I'm not aware of any program or any strategy that we have on a governmental level to act in that case. But I can imagine a scenario how we can act. I think the old mechanism that I just mentioned can be triggered, but in the case of Turkey admitting the commission of the genocide, it will the most effective mechanism to build will be the claims commission between the two countries. That's my understanding, the lawyer, and which will be, I think, a good forum for discussing the claims on property and the reparation claims presented by the victims, the relatives of the victims, and also maybe some territorial claims, though I'm really very pessimistic about the legal justification or legal effectiveness of the territorial claims, the possible territorial claims that may be raised by Armenian side. And with regard to the question of using the term "métier" by President Obama, I do see the lawyer's approach in interpreting the president's speech, and I do agree with that approach. And I do agree that when you're using the terms and using characteristics of a crime or a conduct that are coinciding with the definition, the legal definition given in the document, then you're directly admitting it or you're indirectly saying it. But I think, we should not forget that when we are speaking about the recognition of genocide or recognizing the acts of genocide, we are not speaking of the legal side. Because the term or the label genocide, it means more than a legal term or legal qualification of a crime. It's a more psychological and moral thing that's to admit it. That's my understanding of the issue. So that's why bringing up some elements of crime in the speech of the president is not being enough for Armenians, for the survivors, for the relatives of survivors to be satisfied. That's my understanding. Because it's not only a legal issue. And I think that's it.
Very good. I'll just add a footnote. Why just a bilateral claims commission? Why not a multilateral claims commission? It seems that a lot of other countries have benefited from the Armenian genocide and its denial for quite a few years. And it seems like all of them should pay.
Well, the fascinating questions and important questions. How do we bring about in 2015 a Turkish acknowledgement? Well, firstly, by finding a way to get it into a court. UNESCO was just a thought I had on the moment, and there are half a dozen UN bodies that have got power to refer a question to the International Court of Justice, and there should be, at an international level, the government and representatives of the diaspora and some well-wishers perhaps working on a strategy, because that strategy needs to be multi-layered. One reason why Turkey might make an admission is for fear of an international court judgment. One reason may be if the Section 301 was scrapped as a result of the European Court of Human Rights decision and there was free speech in Turkey. The crucial thing, it always seems to me, about the genocide was that Turkey, it's not down to the Kemalists. Ataturk was hostile to the Young Turks. When he got power, he approved their being put on trial. The people who were convicted were, in 1918, the Young Turks themselves. They were convicted in Turkey, mainly in absentia, but the military commission trials in Turkey, in fact, in 1918, said it all. And these people were convicted of atrocities. So it is not, the Young Turks were a particular perversion in Turkish political history, and the Kemalists and the heirs and the forebears of modern Turkey were not to blame. But the free speech in Turkey may well get this across. So there needs to be a strategy. Why isn't Israel supportive? It is disgraceful, isn't it? I mean, it was awful on the Rome Conference on the International Criminal Court, a court that owes itself to the legacy of Nuremberg and the heritage of the genocide. Israel didn't sign, along with Libya and Iran and North Korea. And that was entirely because everything Israel does is positioned on, will this weaken our position in relation to the Palestinians? And so you've got to, that is sadly the dominant thought of Israel's foreign policy. And it may be a fear somehow, I don't think it's correct, that they will be accused of making life so difficult for the Palestinians that it will be suggested that they are somehow guilty of complicity in genocide, that causes Israel to withhold its support. It is outrageous and a tragedy and a disgrace and a betrayal of all those who died in the Holocaust. But that's Israel today, that's Israel's foreign policy. You mentioned about the way genocide is tossed around. It could be a tactic of devaluing genocide, because there are two different approaches to genocide, both of them dangerous. The first is by a group of lawyers who say, why bother charging genocide? Because you can just charge a crime against humanity. Every genocide is a crime against humanity, but not every crime against humanity amounts to genocide. And so prosecutors say, increasingly, in relation to Srebrenica and so on, they should charge genocide, but they're saying, oh, well, it's easier to prove a crime. Why don't we do away with genocide? That would be to devalue genocide. The other danger is from the loose use of the word, and this is what Bernard Lewis actually said he was protesting against when he made his comments about the loose use of genocide. I don't think the Libyans initially said, oh, Gaddafi is committing genocide. He wasn't. The Cambodian, we all talk easily about the Cambodian genocide because there were 1.5 million Cambodians killed. But in fact, that was Cambodians killing Cambodians for political reasons. It wasn't, it lacked the particular racist and religious hatred that characterizes genocide, the extermination of a race, the idea that your race is so superior, the rest is, and you know, this is, genocide is the worst of all crimes because it is the classification program, it is the superiority of your race and the desire to exterminate another group of humans. So it could be that the genocide deniers would find it a clever tactic to devalue genocide so much. But it is a danger that it's a word that's being thrown around far too loosely. So as for President Obama, yes, he's used this word as a code word. I can't pronounce it. For me, as a simple Australian, yeah, I call it Ned's Jürgen. But that's my fault. But it's fascinating that the G word, when the Rwandans were being slaughtered, when after about 300,000 of them had been macheted to death, it took Tutsis, by the Hutus, still the Americans and the British, because they didn't want to intervene in the Security Council debates, did not dare to use the G word, because that would invoke their duty under the Genocide Convention. So they said what's happening is the breakdown of peace agreement. It's black on black violence, but they never used the word genocide. And it's fascinating that Obama, before he became president, of course, used it and said he would support the recognition of the Armenian genocide after he becomes president. He signals to Armenia, but not to Turkey, by use of this word, which is the equivalent, I guess, of using Shoah in relation to the Jewish idea of the Holocaust. So it's a genocide that Americans, because they need Turkey so much at the moment as an intermediary with Iran, can only speak in code. I think what to do to get the 2015 is a terribly important year for a lot of people. There are enormous commemorations going to be held, or half of Australia is coming over to Gallipoli because it's a sacred place, and British to all those, that massive slaughter in Sniper's Alley and so forth is engraved on our hearts. What I'm going to suggest is that the head of state of Australia should first, on the way, come here on the 24th and be in Gallipoli on the 25th, because Gallipoli was used, the Dardanelles campaign was used as the excuse for beginning the genocide, and I think that would be a way of developing reconciliation. What Turkey has to do, I don't think they'll ever return the land, although some kind of compensation and restitution must eventually be agreed, and the carrot, if you like, is membership of the European Union. Turkey must not, and I hope will not, be allowed to join the European Union unless it acknowledges the Armenian genocide. And that may be the straw that breaks, you say, Kemal's back. It may be the way that Turkey does own up, but there has to be restitution. It's all very well, you see, we all want reconciliation, and the Turks have got a good story to tell, because it was a political perversion, just as the Nazis were a political perversion, and it was longer ago. But you cannot have reconciliation without truth, and it's acknowledging the truth that it's a certain extent.
Well, that certainly sounds like the right last word. And with that, I would like to invite our President Bolosian to make a presentation to our guest, and we'll wrap up this evening.
Thank you, Minister Kiragosian, for your presence here and your comments. I thought it was a very thought-provoking discussion. I thought there were, as promised in the Thinking About Thinking series, aspects of this that we haven't considered before, that we haven't thought of before, and certainly the combination of these ideas I thought was very insightful. I'd like to thank our moderator, Dean Samuela of the Law School. I'd especially like to thank, before I thank our guest, I'd like to thank also Luys Foundation and all the people that put together their help and the publicity for this event. Director Jacqueline Karaslanyan in the front row. Stefan Kazarkian is somewhere here. Thank you all very much. And I'd like to especially thank Mr. Robertson for traveling here, for giving us this very insightful point of view, and for his time and for all the work that he's done for our Armenian genocide within the realm of law. As a token of our appreciation, I'd like to present him with a book of photographs about Armenia so that he remembers his trip here, Armenia by Graziella Di. finally, thank you all very much, our audience, for your attendance today. Thank you.